Hello and welcome to our webinar. Are you concerned that you've created a time bomb that could harm your family? Have you done what you should to prevent your estate being wasted on attorney fees, your family fighting for control, your money going to nursing homes, your money going to your kids' creditors, or your in-laws or others interfering with your estate? If you aren't sure, you're in the right place. In the next few minutes, we will help you decide what planning you need. I will be upfront about our charges, and at the end, as a bonus for watching this webinar, I will tell you how you can get a reduced charge and other benefits. At any time during this broadcast, you can make a free, no-obligation appointment with our attorneys by clicking the button on your screen. Those appointments will fill up fast. You should know that you are not alone. Most families we work with are in the same position. What is precious to you? Why have you worked so hard? I assume it is to protect your family. As a father and family man, I've worked hard to protect my family to the greatest extent possible. But your family faces very real threats when you are not there to take care of them. Things like greed from a family member or heir, or just someone who wants to interfere with the family like in-laws, prior spouses, or other relatives. Nursing home costs are a huge threat that you want your assets to help your family, not just be a resource for medical providers or creditors to grab. You want your money to help your family, not creditors. Fights for control over your estate are a major problem. Lack of proper planning leads to fights that only benefit attorneys. Good planning minimizes future attorney cost. These are all very real threats to your family right now, and too many times I work with families who didn't address these issues until it's too late. And when this happens, the family has to suffer more, the legal charges are higher, and there is much more stress. The goal of estate planning is to pay attorneys the least amount possible. Do you want to starve some attorneys? Then let's do good planning now. Why don't people do good planning? Typically because of procrastination. None of us wants to plan for death and disability, and we wait one more day, one more year until decades have passed. Our firm, Pike & Associates, has been helping families overcome these hurdles for decades, and that is why we wanted to share this webinar with you. In this webinar, I'm going to cover what the specific threats are to your family, how typical estate planning did not fix these threats, and what effective planning looks like. At the end, I will tell you how to get a reduced charge and the full benefits of planning with Pike & Associates. So let's get right to work. So we're going to look at a case study. We're going to look at a couple that we're going to call John and Jane Jones. And we're going to say they have an estate of $700,000. Now, you may say, this is more what my family looks like, or this is more what my family looks like, or this is my family. It doesn't matter. We're all looking at the same issue. We're just going to use this couple, John and Jane Jones. Now, we're going to assume that they have two children, Susan, who's very smart and responsible, and their other child, Timmy, who's maybe, say, got a few issues. So what do they do? Well, first of all, they're planning for the retirement, so they look at the things that they're going to do. They create a to-do list to exercise, vacation, and, oh yes, they need a will. So they go to the local attorney they met at the health club and say, can you do a will for us? And he says, yes. How hard could it be? And this is the will that he creates, and we see these types of wills all the time. It says, all to the surviving spouse, and when the last of the spouses die, it goes equally between the children, Timmy and Susan. Sounds good, right? That's what most people think. So what happens next? Well, unfortunately what happens is John has a stroke. John becomes mentally disabled, not just physically disabled, but actually unable to make his legal and financial decisions. When we get to this situation, the legal solution for that is called guardianship, We are glad we have guardianship to fix these problems, but it's like open heart surgery. It's a necessary tool in the attorney's toolkit, but it should be avoided at all costs because it is extremely expensive. Guardianship is court-supervised living, both with your health decisions and your financial decisions, and you do that with the assistance of your local friendly attorney, but that's expensive. So their planning did nothing to avoid planning for incapacity, and we'll talk about that later. But then what next happens? Unfortunately, John passes away. Now, are they going to need to probate that will? Yes. A will is not effective. It has no legal impact whatsoever until it's probated. So is probate a good or bad thing? Well, there are some issues with probate. One, we need to know what is probate. The purpose of probate is to change titles out of the decedent's name, to take the assets that John owns and transfer them to Jane, and along the way we have to pay John's creditors. So we are actually literally taking everything that John owns and we want to get it into Jane's name. So that's what probate is all about. But there are problems. If the will is not drafted right or there is no will, probate can be time-consuming and expensive. You have court fees, publication fees, bond fees, executor fees, and of course, attorney fees. A second problem is that the doors of the courthouse are open to everyone. So when you probate a will and you tell people about your estate, that is public information. And that is a concern to some people who have a particular privacy issue. So if there are assets or things about their planning that they don't want others to know, then probate is not a good solution. Another problem is that we don't want to have multiple probates. Texas is actually a good state for probate. Texas has streamlined probate laws so that when we have a well-drafted will, probate's not expensive. Why would you have multiple probates? You have multiple probates when you have real property in another state. That is a problem because probate, for example, in Oklahoma or Louisiana is much more expensive than in Texas. Florida and Ohio like to tax properties. New York does not believe in independent administration, and California is crazy. So we need to, at all costs, avoid multiple probates. So those are the summary of the disadvantages of probate. It can be potentially expensive, time-consuming, public, and you don't want to have multiple probates. So you must address these issues one way or the other. So what will Jane do after John dies? Well, what is most likely to happen is that someone like this comes along, someone like Randy. Who's Randy? It's the person that Jane used to date a long time ago before she met John. When John is off the picture, he comes back and he remarries her. What's the problem? Well, they do new wills. They go to the same attorney that they went to before. They get a will that says all to the spouse and then to the children. So what happens if Jane dies first? All of her money goes to Randy. That includes all of John's money goes to Randy, his competitor for his wife. Does he want that to happen? No. Who is hopping mad? Susan and Timmy are furious and will spend outrageous amounts paying attorneys to fight with Randy. We must plan to avoid this because it's too common. 65% of people over 65 get remarried when they are single. So this is not an unusual situation, it's the most common situation. But let's assume we never had Randy in the picture. What if Jane becomes incapacitated when John dies? Does the fact that we did a guardianship for John help and solve the problem with Jane? No, it doesn't. In fact, it's probably worse because we have potentially Susan and Timmy or others fighting over the guardianship. What other problems might arise? Well, will our children be pressured out of their inheritance? What if the money when Jane passes goes to Susan? We're concerned about Timmy, right? But how about Susan? Should we be concerned about her? Well, it may be that the only bad decision she ever made in her life is to marry this guy named Bruno. And what's the problem with that? The problem is when she leaves her assets or gets the assets from the inheritance, although they're separate property, like those ingredients of those cookies, once she puts them all together with all their other assets, they become like a baked cookie and you can't tell the difference, which means Bruno can get at those assets, especially in a divorce. So we need to plan for that. Over time, the money that you leave your children, although it's separate property, will be commingled in a way that it's community property and indistinguishable. If we handle it the right way, we can prevent any of that property being commingled. So that's good estate planning. So you look at these problems and say there must be a better alternative, and there is. And that's what we're going to talk about throughout the rest of this seminar. So the better alternative is to have a properly planned estate, and we do that with one of two options. One is with a living trust, and one is with a last will and testament. So we're going to first look at what is a living trust. Most people are familiar with wills, but less familiar with a living trust. So what is it? Think of it like it's a box that we label a living trust. What's the purpose of the box? The purpose is to hold title to your assets. We literally take the assets of John and Jane Jones that they hold in their own name individually, or they might hold it in joint tenancy or tenants in common, and instead we title it to be in the living trust. We literally take the assets they own and put it into the living trust. We put them into the box. So what you need to know is that there are three positions of a trust. There's the trust makers. Those are the people who own the assets and put them into a living trust. Now, if you've heard of a settlor or a grantor, there's all these different names, but regardless of the name or title that's used, it's the person making the trust. Secondly, we have a trustee. That's the people who manage the assets in a living trust, that they have the right to buy, sell, trade, borrow, etc. And the third role in any trust is that of a beneficiary. It's the one you want to be. It's the person who gets to spend the money and use the assets in the living trust. All you need to remember is that the trust maker creates the trust, the trustees manage the trust, and the beneficiaries get to use the assets and income of the trust. So what makes it a living trust? Well, in John and Jane Jones's case, if they create a living trust, that means they're the trust makers. Well, who do they want to manage their money while they're living? Themselves. That makes themselves the trustees. And who do they want to spend their own money while they're alive and healthy? Themselves. So they're the beneficiaries. So what makes it a living trust is that they hold all three positions. So the trust makers, trustees, and beneficiaries. That's it. That's what makes it a living trust. The specific terms of a living trust are important and are customized for each person. So, how does this look for planning purposes? It's business as usual for John and Jane Jones. They are in control. There's no change in property tax. They don't lose homestead exemption. They don't even file a new trust form. So what's the purpose of a living trust? Why create one? It is a standby device. We have to remember what the purpose of probate was. What was the purpose? To transfer the assets of the estate from the decedent to the survivors. With a funded living trust, if you put all your assets in the trust, that's the name of the assets. They're titled in the name of the Jane and John Jones Living Trust. When someone passes away, we don't have to retitle the assets. So do John's estate needs to go through probate when he passes away? No. There is no probate if you have a fully funded living trust. Though remember, the main purpose of probate was to change the title of the assets, and we don't have to do that. So that's a clear advantage of a living trust. Now, does everybody need a trust? Well, as you can see, doing your probate in advance might be a hassle. You have to change title to all the assets. So really, there needs to be some tangible reason other than just avoiding probate to choose a living trust, in my opinion. It could be that you have multiple properties in multiple states, or you have a privacy issue. But very commonly, it is because of the risk of guardianship. Remember, we talked about guardianship and how expensive it is, and we want to avoid it. Powers of attorney are a simple and easy method to try to avoid guardianship. There are financial and medical powers of attorney that really everybody needs. Every adult needs powers of attorney, regardless of how many assets they have or what age they are. So, does it work? Well, it works like a Jeep does. If you're trying to get from point A to point B, a Jeep is a very effective vehicle. But is it effective when there's incoming fire? No, it's not. In those cases, you need something more like an armored personnel carrier. The armored personnel carrier is the trust. It is more durable to deal with fighting. So if there's going to be fighting over the control of your money when you're incapacitated because of the nature of your family or people who might try to stick their nose in your family's business, then a trust is a better planning vehicle. And usually that's the issue that makes us decide in consultations with the client to recommend a trust versus a will. So let's go back and look at the other alternative. It's a will. Most of us understand a will, but the key is to have a properly drafted will, both technically that you avoid the expense and problems of probate, and that you waive bond, you don't have to go find the witnesses, and it achieves your objectives. The all to spouse, then to children will does nothing to protect you from long-term care, asset protection, and taxes. Signs that your will may be out of date include that it has been more than 5 years since you have changed your will. This doesn't mean automatically that the will is bad, but it means that you should look at it. If you have a large IRA, if your family situation has changed, if the value of your estate has grown, or if you're concerned about long-term care or nursing home costs, all of those are reasons that your will may need to be updated. So, does your will or family trust protect your family? That is the key question. Does what you have now or what you were thinking about getting protect you from nursing home costs, the Randys of the world, the Brunos of the world, and creditors? If it doesn't, you don't have a very good will and you haven't protected your family. Let's talk about long-term care and what a threat it is to your family. Most people are aware that long-term health costs can be very substantial. In fact, 81% of all healthcare expenses are long-term healthcare costs. Well, but insurance will cover that, right? No. Unfortunately, Medicaid is the only federal program that pays for long-term care. Private insurance and Medicare do not pay for it, and Medicaid is a welfare program, and it's very difficult for most people to qualify for Medicaid. So here's the cruel healthcare roulette wheel. Green is good and red is bad. Cancer is good, you ask? It is only from this sad point of view. It's basically an insurable problem, whereas dementia and Parkinson's and Alzheimer's, the help you need is not so much medical intervention, but help with the activities of daily living, and that insurance and Medicare do not pay for. So it's a very cruel roulette wheel. And the average cost of care can be extreme as you move from home care to assisted living to nursing home care. Costs can easily exceed $400,000 for reasonably priced long-term care options. So you need to do planning because 500,000 families a year become destitute due to long-term health care expenses. No planning is not the option. You must be proactive in how you plan. You must plan a strategy now that plans to allow to leave assets to those you love in a protected way. So let's talk about that protection a little bit. Let's say John goes into a nursing home. Does John qualify for Medicaid? No. He has more than $2,000 of countable assets, and he has more than $2,200 of income. He does not qualify for Medicaid. But there are two types of Medicaid assets. This is really technical. There are countable and there are not countable. So what kind of assets do you want? You want not countable assets. So how do you turn your assets into not countable assets? Well, one thing you can do is use a last will and testament or revocable living trust to leave assets to your spouse, children, and beneficiaries in a way that they are not countable. And you can also insure against long-term care needs. Long-term care insurance is very advisable for people who are relatively young and healthy. So let's talk about the different levels of planning. Planning level number one. You don't leave assets to your spouse or to your children or your heirs where they are accountable. Very few wills or trusts deal with this basic level one of planning. So when John passes away, he owns half the community assets, half of that $700,000. If he leaves it all to Jane, she now has $700,000, and she must spend all of that money to qualify for Medicaid. That is totally ineffective planning. What's planning level two? That is saving your own assets from ever being counted from Medicaid planning. And we'll talk about that in just a second. The third level is you're about to enter a nursing home, and it's called crisis planning. We're not going to talk about that today because you don't want to be in a crisis. Let's do planning so that we're never in that situation. So here's a short introduction to Medicaid planning, or what some people call elder law. You need to know about the 60-month look-back period. For 60 months before you apply for Medicaid, Medicaid looks back and sees, did you give any gifts during that period of time? And if so, those gifts are counted back into your estate. So what does that mean? If you give gifts more than 60 months prior to qualifying for Medicaid, they are not countable assets. And you remember, that's what we want, not countable assets. How can you create not countable assets? Put some of your assets into a lockbox trust, a trust that is not like a living trust. You are not the trustee. It is locked down for future generations. Well, does this work for everybody? It works for the middle class. If you're in the middle, it works. If you're too wealthy, you don't need this planning. If you're too poor, you're going to qualify for Medicaid. But if you're in the middle, some of your assets, maybe a great deal of your assets, can be saved and still qualify for Medicaid. Will you be okay to give away some of your assets? That depends on your family and the level of trust in your family. So we must carefully look at that before we do this. This is not planning that everybody should do or should be done on an ad hoc basis. So the keys: you want to be healthy, have a stable income, probably retired to do this type of planning. So planning level number one, remember, is don't leave the assets where they are accountable. That's what we're going to pick up and talk about from here on out. So to do that, you want to leave John's assets to Jane in a way that are not countable. Remember, they had community property. They have two halves of the assets. Neither of them owns the whole. They each own a half. So we want to leave John's half to Jane in a way that is not countable. That allows you to keep in quality care and then qualify for Medicaid if needed, and preserve some of your assets for your family members. How about for Susan and Timmy? Do we just want to leave the assets outright to them? Well, if we're concerned about Bruno, the answer is no. If we're concerned about Timmy and maybe an addiction or spending problem, the answer is no. But what does the future hold? We don't know, because we don't know if they're going to be in a car wreck, if they're going to have a medical problem. Don't we want to leave the assets that are protected so they don't go to a lawyer who sues them for a car wreck, or to medical providers who want to get at those assets to pay for their medical care problems? So we want to leave the assets also to our children in a non-countable way. That is level 1 planning, leaving our assets to our spouse, our loved ones, and our children in a non-countable way to protect those assets to the greatest extent possible. So we're going to protect those assets from a variety of threats. We're going to protect them if the surviving spouse remarries. We're going to protect the surviving spouse if they have a long-term care event. A child or other heir who receives an inheritance, we're going to protect those assets from a divorce, the assets from going to in-laws or going to creditors. That's just good planning. And it works whether you use a will or a living trust. So how it works is, although there is no trust with a will created immediately, when John dies, we create a trust for the benefit of Jane. John's assets go into this trust and we've locked them down, made them non-countable from Jane, and she can't leave them to Randy. John's decided that his assets are going to go to Timmy and Susan. It works the same way with a living trust. The only difference is we created the trust now. When somebody passes, we change the trust into 2 parts, a countable part and a non-countable part. The part that we somewhat locked down, we allowed Jane, the surviving spouse, to use, to get at, and spend, but they're not fully legally hers. So they don't count for Medicaid purposes and they're protected from creditors. And we still have determined that those assets are going to Susan and Timmy. And when Jane passes away, so to review, if John has died, he's the trustee and the beneficiary, Jane's going to have access to the money. She's not going to be deprived of any of the money. She can have it. She can have all the income. She can have the principal for her needs. What she can't do is rewrite the rules for the assets to send her money to Randy or to allow creditors to get at what was John's money. So when Jane passes away, what will happen to the estate? Well, if we properly created an asset protection trust, we made those assets protected for Timmy and Susan, protected from all of the threats that we have discussed. And that leaves the assets in a protected form. Here are the points to remember. The type of asset protection planning we're talking about can be done with a will or a living trust. And this isn't just for the wealthy. In fact, it's more for the middle class. This type of planning is to protect assets for your surviving spouse from remarriage and long-term care events and keeping your family in control of how and when they use your assets. So, you need an attorney to help you do this. We hope that you choose Pike & Associates, but you should ask your attorney these things. Number 1, does your will have family protection provisions? Does your will or trust help qualify your family for Medicaid? And is your attorney concerned about you for the long term? At Pike & Associates, we want to see you succeed. We don't want to just see that you have good documents. We want to see that you actually have a successful estate. So let's look at the cost for a complete estate planning portfolio that does meet your needs and protects your families. If you're a single person and you choose the living trust, and that's the best answer for you, this will be the charges. If you choose a last will and testament, this will be the charge. And there's always a charge of $250 to deed property into the living trust. This is not a charge that needs to be done with a will. In either case, you get a 10% discount of those fees for attending this webinar. You remember, you're going to get a word, and I'm going to give you the word in just a minute. If you're a married person, these are the charges. They're not double, but they are higher because we're doing more documents. Again, the same issue with the deed and the same discount, but the discount is potentially higher because it's 10%. To get the discount I just talked about, you need to use this word, SMART, when you make your appointment. By giving us that word, we will give you the discount. And why SMART? Because you're now smart. You now know what you need to know to make good decisions for you and your family in your estate planning. And we want your estate planning to be good not just today, but into the future. We do that with our family protection plan. and we give it to you free for 1 year when you create your plan. That allows your plan to stay up to date by us performing a great deal of the services to change and revise that plan free, whether it's the change in the law or if you decided a different person you want to be your successor trustee or agent or executor, all of those roles that we set up in a estate plan. So we want to keep in touch with you. We want to make sure your plan is good, and we do it with a family protection plan. So that is what we do to protect your family through the dangerous roads ahead, to protect you from these threats. Our goal at Pike & Associates is to remove fear and unpredictability from your estate planning decisions. We hope this webinar has helped you make good decisions for you and your family into the future. Thank you.